Okay, we will call the next case, which is Michelle Demske versus Martin Fick and State Farm Automobile Insurance Company. This is another mini oral argument on the application. Each side you will have 15 minutes. Again, a 2-minute fire-free zone. And Mr. Banka, if you would like to reserve any time for rebuttal, you may do so, but just keep track of it yourself, please.
Thank you, Your Honor. I would like to reserve 2 minutes for rebuttal, please. Good morning, Justices. May it please the Court, Keith Banka, appearing on behalf of plaintiffs in this matter. Actually, I think the prior oral argument kind of went over a lot of what we're going over here. And there are 3 dates with the fee schedules that are important. You have the June 1st, 2019 date, the effective date of the new legislation. You have July 2nd, 2020, the date that Andrew recognizes the date, and DIFS, and I believe the state is largely recognized as the date that these new policies could be sold in the state. And then you have July 1st, 2021, the date the fee schedules actually became applicable to care. I think in this case, the key date is the July 2nd, 2020 date. And as Inderi recognized, this is the date that the insurers could finally start to sell policies that reflected the changes. Prior to that, the old policy still allowed for unlimited PIP. So when the Demskes were injured in this case, when they went to the emergency room, when they got the initial treatment, that was subject to no caps at all. And so if you, judging by the 2020 date, that's when State Farm could then offer a policy that incorporated the fee schedules. And I think the MAJ briefing points this out, that prior to July, in fact, prior to May 6, 2020, State Farm had not received approval to raise their rates to reflect the new changes. So when the Demskes purchased their policy, it would have been the same rate from before the amendments when it would have reflected unlimited PIP. So defendant is arguing in this case that the Demskes, even though they received no benefit in the form of reduced premiums, now are subject to these fee schedules, even though the policy reflecting the fee schedules couldn't have been sold to July until July 2nd, 2020. That the defendant and the Court of Appeals interpreted this wrong. If you read Andrew discussed the difference between statutory rights and contractual rights. And in that case, it placed the emphasis on contractual rights and set the benefits as the contract stated on the date the person was injured, and said that the amendments could not affect those contractual rights. Well, that should apply here. When the Demskes were injured, they were entitled to unlimited no-fault benefits. They paid a premium for unlimited no-fault benefits. The defendant insurer had not yet received approval to lower their rates based on the amendments. So the fee schedules were entirely separate from the policy that applied. So the Demskes are stuck without the benefit of any bargain, yet now they're faced with the fee schedules. And I think that's the key distinction here. And I think actually Attorney Garish argued this well, that the key date is this July 1st date. And from that day on, you apply everything. You're applying everything from the new amendments. Prior to that date, you have this distinction between statutory and contractual. And here, contract would trump, since the contract was written for unlimited and provided unlimited in the beginning.
Counsel, what do we do? I mean, I agree with you, obviously, what Andrew said. Obviously, that case vested entirely before the new laws went into effect. In this case, again, we're in this straddle period. Yes. The policy was issued after the new amendment, or the accident occurred after the new amendments, and the policy was issued after. Why doesn't it? Why wouldn't the law that's in place at the time of the accident, which included this future fee schedule, why wouldn't that apply? I mean, I'm not sure Andrew really says that the law in place at the time can't apply.
Well, the law in place at the time didn't apply the fee schedules to the Demskes accident, nor did it apply to the Demskes policy. And that's because the new policies reflecting the fee schedules could not be issued until after July 1st, 2020. So whereas you had this law that enabled the insurers to now impose fee schedules and put these fee schedules in, those didn't kick in until the policies could reflect those changes. And those policies could not reflect those changes until that July 1st, 2020 date. And then after July 1st, 2020, the policies could say, as of July 1st, 2021, all your care is subject to a fee schedule. So if
Counsel, under that reading, what takes effect on the effective date of the statute, right? So if you're saying this has to be tied to that year later, of course, there are a number of provisions that explicitly say policies issued after that date. So what's left?
Well, that's the triggering date, and it allows the insurers to, I guess, prepare and start writing these policies, getting approval of these policies, and then so you have this year lead-in to where the insurers can adjust, can start going to the consumers, offering these policies, or writing these policies, getting approval from DIFS for the rate changes, and then they can start offering to the consumers on July 1st, 2020. So on June 1st, 2019, that simply, the effective date allowed the groundwork, or allowed everything to start, was the starting date. However, the changes were not implemented until the policies changed in July 1st, 2020. And just to conclude quickly my argument, I think ultimately, if you read the statute as a whole, the legislature did intend a phasing in period. And they didn't want this abrupt sea change, and they wanted the insurers to follow a process to change their policies. They wanted consumers to be informed as to the changes to their policies. So they put that 1 year period in to give that cushion. And in that interim, there's a status quo where policies remain the same and provided unlimited benefits. And that changed on July 1st, 2020. Well, this accident happened before the July 1st, 2020 date, so unlimited, we believe, should still apply, and the Court of Appeals got it wrong.
Good morning, Your Honors. May it please the Court, Paul Hudson on behalf of State Farm. Your Honors, there are a lot of dates to keep track of in this case. The key here is that every single one of them happened after the amendments to the No Fault Act. The policy renewal, the accident itself, all of the medical treatments in this case happened after the June 2019 amendments. That makes this case a lot more straightforward than the Andery decision or some of the cases that this court has wrestled with since, where some of the dates straddle the amendments and the question is which ones control. Here, everything is after, so there are no surprises here. There are no retroactivity issues. Plaintiff's policy expressly incorporated the No Fault Act and any amendments. And that means that on the very day he signed his policy renewal, it was already all laid out in the statute exactly when and how these fee schedules would be phased in, down to the exact dates, down to the exact percentages. And then State Farm paid for the treatments exactly according to that schedule. For roughly the next 2 years, the fee schedules didn't apply. Then for treatments rendered after July 1st, 2021, State Farm paid according to the fee schedules. And as the Court of Appeals correctly recognized, all of this is how it was supposed to work. It's consistent with the statute, it's consistent with the policy, it's consistent with this court's decision in Andery. Now the plaintiff's argument is essentially State Farm was somehow precluded from applying the fee schedules because on the date of the policy renewal, the fee schedules hadn't kicked in yet. But nothing in the statute actually says that, nothing in 3157, nothing in 2111F. And there's nothing unusual about the legislature phasing in reforms over time. No changes at first, and then we're going to phase in the changes to give everybody a chance to react to the new system. But what's missing here, and it's fatal to the plaintiff's argument, is what we had in Andery. Because the only reason the court would entertain an argument not to apply the plain language of this statute as it existed on the date of both the policy renewal and when the contract rights vested on the date of the accident is if there were some concern about retroactive impairment of contract rights. It is undisputed in this case, and I don't use that term loosely. It was conceded in the Court of Appeals argument. Court of Appeals noted in their opinion that there's no argument here that any vested contractual rights were impaired by the amendments, by the application of the fee schedules. I don't have a whole lot more to say than that, Your Honors. I'm happy to answer the court's questions, but otherwise we ask the court to affirm the Court of Appeals decision, or since it was a published decision from the Court of Appeals, it was thorough, it laid everything out. I think this is a good case for this court to simply now deny leave to appeal. Thank you, Your Honors.
I think the flaw with defendant's argument is that the intent of the amendments to the No Fault Act was to pass cost savings on to consumers. The fee schedules, everything was designed to lower the cost of no-fault policies. None of these savings were passed on to the Demskes here. They did not, when they renewed, they didn't receive any of the cost savings associated with the amendments. They paid the same premium. And the statute is written that they don't get any of the rebates on their premium. So looking at the intent of the legislature and the way the cost savings provisions are written, it seems to indicate that they did not intend for these policies, these cost saving policies, to take effect until July 1st, 2020, when they could be offered. So that would seem to support that those injured in the interim would still be unlimited to, or still be entitled to unlimited PIP, because none of the cost savings were passed on to them, when the entire point of the fee schedules was to save costs. So I would just argue that the fact that the Demskes didn't realize any savings in their policy cuts against defendant's argument that the legislature intended these fee schedules to take effect as of June 1st, 2019.
Thank you. Okay, the case will be submitted.